Case number 47, People versus Reginald Powell. Good afternoon.
Good afternoon, Your Honor. If I could just have 2 minutes for a possible rebuttal.
Yes, sir.
Thank you. The test of probity versus prejudice to determine the admission of evidence of third-party culpability cannot adequately safeguard important constitutional considerations.
So, counsel, if we don't overrule Primo based on that argument, do you lose under that standard?
Not necessarily, Judge, because the trial court decided this on Primo grounds and the appellate division considered it on state evidentiary principles and denied it on that basis. So not necessarily.
If we apply the Primo standard here, do you lose then?
I don't think so.
We have to overrule Primo.
I don't think it's necessary, Judge, but I will say this. I think there's a passage in the record, and this comes at the appellant's appendix, 521 to 522, where finally, after all the arguments that's taken place, and further arguments take place, and counsel has brought up Chambers and the right to present a defense and reasonable doubt, where the trial court has this epiphany. And this is what the trial court says. The trial court says, listen, I get what you're saying. I understand the fact that there's Chambers versus Mississippi. I understand there's a right to present a defense. And the court essentially says, I'm constrained by the rule in Primo because the Court of Appeals has said there has to be this threshold showing. So despite the fact that I understand your argument, I have to reject it.
It's just a question. It's not an argument.
Yeah. I think right there,
if you apply that standard, if you were, let's say, Primo passes constitutional muster, aren't you balancing doing that test based on what the representations of counsel were at the trial as to what he or she wanted to use this evidence for?
Well, I think what you have to do is view that in terms of the fact that when we started the trial, the judge gave a ruling and said, I'm not letting you bring that in. I'm not letting you opening on the policy. I'm not letting you cross-examine Warren Powell on the policy. So right there, defense counsel has to do what any good defense counsel does. If there was a suppression motion and it was denied, he'd have to now proceed on a different basis.
But
that's what he had to do.
In the trial, defense counsel raises this again, right?
He does raise it again. And instead of running into a brick wall, because the judge said to him on a number of occasions, listen, if you don't put him in the house, this doesn't come in. So instead of running into a brick wall, what he does is he says, Judge, I'm trying to create reasonable doubt. This is Chambers versus Mississippi. I am trying to present a defense, and you're preventing me from presenting my defense. So he presents the constitutional argument, and I think that's the argument that has been preserved. They've both been preserved, but I think this Court really needs to decide this, because when the trial court says what it said, it indicated that he felt constrained by Primo because he understood the constitutional arguments. So I think it's indicative of the fact that trial courts need guidance from this Court with respect to the constitutional consideration.
But is it in the record anywhere that his calculation was, I am not going to push this judge because of the suppression motion, because it's equally an inference, I think, that he didn't want to point the finger directly at his brother?
I think, Judge, like I said, he had to proceed with what he had. He had to play the hand he was given. Had the trial court ruled that the evidence of the policy came in, well, now all the elements are there. The opportunity is there. The access is there. There's forensic evidence which points away from the appellant. There's forensic evidence that points towards the presence of more than one male. Had he been able to show motive, then he would have had all of the elements and been able to present a complete defense. But he was deprived of presenting a complete defense. The jury had to be wondering at the end of the case, well, you've shown us opportunity, you've shown us access, you have shown us the forensic evidence. There's also other evidence I'd like to review later on. But what he isn't able to show the jury is why. Why would Warren do this? He wasn't able to show either a jealous motive or a motive of a financial motive.
And that's accusing the brother.
Right.
But he repeatedly says he's not going to use it to do that.
Right, Judge, because he knows that the trial court has already indicated if you can't put him in the house, I'm not allowing you to bring it in under that basis. So he's scrambling. He's doing what good trial attorneys do. He's making the best of a bad situation.
But doesn't all the case law require some connection that's more than mere speculation, something to either the scene of the crime or the crime itself, and that's never been found to be unconstitutional.
Well, Your Honor,
and that prejudice be weighed against probative value and all of that in part of the analysis of whether this evidence, whether you call it third-party culpability evidence or pointing the finger at or pointing the finger away, it doesn't matter. It's all the same thing, isn't it?
The problem here, Judge, with the Primo rule is on the probity side of the equation, it requires this heightened proof from the defendant. And on the prejudice side,
what's heightened about saying it has to be probative and not prejudicial, and it has to, and in order to be probative and not just speculative, then there has to be some connection. Anybody that knows anybody is going to have some motive and opportunity to kill them.
I think, there was a lot more than that here, Judge, and that's really a very, it would be improper to characterize the evidence that way.
But I guess the point that I'm making is that, as I understand it, our law says that, yes, you have the right to present a defense, but there are limitations to that right. We're not just going to allow you to throw things at the wall that are going to confuse the jury or,
The argument I'm making, Judge, is this. That's the problem with the Primo rule. There's too much emphasis on how far the defendant can go to show that the third party is culpable. And that's the wrong focus. There's a better rule. And if I could just read, this is from the D.C. Circuit in the Winfield case, and it's a two-part test. There must be proof of facts and circumstances which tend to indicate some reasonable probability that a person other than the defendant committed the charged offense. The focus,
is that constitutionally required?
But yes, Judge, I believe it is. The focus, and this is the verbiage that's missing from Primo. The focus of the standard is not on the third party's guilt or innocence, but on the effect the evidence has upon the defendant's culpability. And in that regard, it need only tend to create a reasonable doubt that the defendant committed the offense. And that's the problem here. On the one hand, with Primo, you have it can't simply be prejudice versus probative. That's insufficient because prejudice, the judge ruled in this case that the fact is there was motive. The policy could demonstrate motive on Warren's part. There was opportunity. There was access, all demonstrated by evidence the people brought in with respect to the cell phone records and Warren's own testimony where he was on the 28th. The problem is the judge ruled it's going to mislead the jury, and he also ruled that it wasn't going to cause delay because he was already under subpoena from the people. It could mislead the jury and it could prejudice the people. But I'm saying the constitutional part of it is this, and the verbiage that's missing from Primo is it's inaccurate to view the prejudice as 50% of the equation because if the defendant can create reasonable doubt, then to look at it just from prejudice versus probative, the prejudice to the State must be subordinate to the right to present a complete defense.
Maybe perhaps I've just misunderstood your argument, and perhaps I'm just asking you to, again, answer really Judge Garcia's initial question. Are you saying there's no way to read Primo or to interpret Primo so that it doesn't require that the defendant actually point to the third party as the actual perpetrator of the crime? You're saying there's no way to read Primo that way?
No, I'm not saying that, Judge. No, okay. I'm not saying because in this Court's decision in Negron last year, Judge Lippman, I believe, wrote the opinion. It talks about the fact that there wasn't, like in Primo, there wasn't a ballistics report and there wasn't a witness who put
So then why don't we stay with that? How, assuming for one moment that that argument is persuasive, that you don't have to point to the other person and say they did it, how did you meet what otherwise would be this Primo standard without that requirement?
Okay. There was, as I say, there was evidence of proximity. There was evidence of access. There was an ongoing relationship between Warren and Jennifer. There was the 13-minute call that happened the day before the incident. There was a 1-minute call, the last phone call that was placed from the victim's phone to Warren's phone on the 28th. That was 11:41 a.m. At 12 p.m. that day, Warren is parking his truck in the DPW lot. He's 2 blocks away.
So by the way, essentially, why aren't you arguing that this is the person who did it with that kind of proof? If your position is that's enough proof under Primo.
Your Honor, he couldn't give the jury the motive quotient. And without the motive quotient, the jury had to be wondering.
Assuming, counsel, that we agree with you, and I'm not saying we do, and the judge erred in not allowing the motive portion in about the insurance policy. Why isn't it harmless error here on this record?
Judge, I think there might be harmless error with respect to the possession of the vehicle, with the theft of the property, but there isn't a harmless error with respect to the homicide, because there was no admission here. A lot of what the defendant said a lot of what happened was consistent with what the defendant told the police. He found the body. Who's going to believe me? I'm on parole. I don't think there was harmless error. And one of the cautions with respect to that's pointed out in Holmes versus South Carolina is that looking at the strength of the people's case to make a determination of whether or not evidence of third-party culpability comes in the case is wrong.
Thank you, Mr. Gaetani. Let's hear from your opponent. You have 3 minutes. 2 minutes rebuttal, right? Yeah.
Maria Wager for the people of the State of New York as respondent. Good afternoon, Your Honors. All throughout this trial, even when defendant made his post-verdict motion to vacate the conviction and at sentencing, he insisted that he was not and never was offering evidence to support a defense of third-party culpability.
He says he doesn't have to. He says all he has to do is show reasonable doubt.
Well, Your Honor, he's making a circular argument. In order to show reasonable doubt, he's trying to show he didn't do it, that someone else did. He's trying to point the finger away from himself at someone else. Now, why he did that was because he wasn't doing what any good defense attorney would do, as my opponent stated. What he was trying to do was to ignore the court's ruling. The court made a ruling that his profit evidence was not sufficient. So what he was trying to do was to plant a seed in the jury's mind about Warren and about Susan Wesley without saying that's what he was doing. Because if he wasn't pointing a finger at them, how was the evidence relevant?
So what if the judge is wrong about not letting him put in that evidence, at least about Warren?
Well, our position is the court was not wrong, but harmless error
Let's say we disagree
analysis.
with you. Let's go to the harmless error analysis. Let's say we disagree with you. He's willing to concede everything except on the homicide.
Harmless error analysis does apply. He was referring to in Holmes, when the court is making the decision whether to admit evidence and using the conventional balancing test. It's wrong, it's unconstitutional to focus on the strength of the people's case. Because in South Carolina, what they were doing was saying if the people's case is strong, it doesn't matter how probative defendant's evidence is. It doesn't matter that it causes no prejudice or confusion. People's case is strong, your evidence doesn't come in. That's what they said was unconstitutional. The harmless error would apply here, and I do submit the evidence of defendant's guilt is truly overwhelming
So
for each
your
of the
position
crimes.
is the only way that you can proceed with third-party culpability evidence is if you take the position that the particular person that's relevant to that evidence is indeed the perpetrator of the crime? That's the only way you can pursue that?
That is what third-party culpability is.
I was
Well,
curious.
no, I need not, let's say my point is 5 people had the
Sure.
opportunity and the motive, but I'm not necessarily pointing to any particular one of them. I thought your position is you have to point to one of them, that that's the
You
real
can-
perpetrator.
You can have several alternate suspects.
And then why isn't that just challenging your reasonable doubt? Whether or not
He's
you've
saying-
established reasonable doubt.
That's not what he was doing here, Your Honor. He wasn't saying someone else did it. He was saying Warren did it and Susan Wesley did it, and this is the evidence that points to them, but I'm not accusing them, at least not yet.
The judge says you can't say the defendant didn't do it, somebody else did it, and that it is an essential element of third-party culpability. You actually have to accuse somebody. Is that your
Right.
understanding of the law?
Yes, Your Honor.
Well, if the evidence that he wants to put in is that there was a $500,000 life insurance policy payable to Warren, isn't he pointing it? I mean, why?
He was doing it,
So
but
why wouldn't it come in? In other words, he doesn't want to say it was my brother. I mean, he just wants to lay it out there. And I would think anybody would assume obviously Warren Warren, as counsel is saying, had everything, access and everything else.
Well, I disagree that he had all that, Your Honor. I think all he had here was a speculative motive. His proffer was that this policy existed and that Warren was a beneficiary, but he didn't even come forth with that Warren knew about the policy. The only information the court knew was that Warren did not know he was a beneficiary until after Jennifer Katz died.
But that's a different reason to not let it in, right?
Well, Your Honor, what I'm saying is motive alone is never enough, and that's what this Court said in People v. Gamble. And that's a good rule, because as Your Honor said, when somebody dies, you can come up with 5 or 10 people that either benefited from the death or had some animus toward the victim. Motive is not enough. There has to be a connection to the crime, and then motive can come in.
What Judge Rivera and I were saying is, he says you have to point your finger at someone. And it seemed to me that if you were saying there's a motive here or there's a reason here that $500,000 life insurance policy, you are pointing a finger, even though you're not saying, therefore, it's Warren.
Yes, Your Honor, and I think that's the way the trial court saw it. So even though he's saying, I'm not doing third-party culpability, the court saw it for what it was and ruled you didn't meet the threshold. But the threshold requires something more than just a speculative motive. And he's saying opportunity and access, but Warren...
I could see the speculative motive if all he says is, oh, he was going to make some money off her death. But here there's an actual life insurance policy where indeed the person that is most suggested in this particular scenario is an actual beneficiary and did actually collect.
Yes, Your Honor.
What's so speculative? The former lover, right? The former lover who gets money off the life insurance policy, who otherwise has access, understands the woman could get into this home. I mean, what's so speculative? Is this really like someone who she doesn't know at all? That's speculative.
But that's not the standard. The standard can't be they have a motive, they're going to benefit, and they knew her. Because then that could be thousands of people.
Okay, what more do you need?
What you need is a connection to the crime. And the language that was quoted in Primo from Greenfield is apt. It's a proof of connection.
Let me ask you this. What if his DNA is on the tie? You can't get that, right? His
DNA was not on the tie. And I disagree with my opponent saying there's forensic evidence that points to another person, because that's not accurate. There was some DNA samples that were of low threshold and cannot be identified. Defendant's DNA was all over the place.
You mean you couldn't exclude him off the tie? Is that what you're saying? Because you didn't have a sample good enough?
Defendant was excluded from the tie, and I believe the tie had female DNA on it. She had 2 teenage daughters. It was a hair tie, a polka-dotted hair tie. That still doesn't get you to Warren. There was nothing that connected Warren to the crime. He has a general opportunity. Opportunity doesn't mean that you're in the neighborhood. Countless people are in the neighborhood. Under that theory, I had opportunity. Anybody in Westchester County, anyone who could knock on her door.
Yeah, but that's speculative. I'm not disagreeing with you about that. But he's not saying that it's just the life insurance policy, right? He's got sort of these other things about it.
No, but the other things are very speculative. He's saying opportunity in that he was around. That's not what opportunity means.
There was some discussion of the sister Dana, I believe her name was. What about her? I thought that you attempted to put proof forward as to her that she would argue that Warren was jealous of the relationship. Is that accurate?
The defendant had asked Warren on cross-examination, did you tell Dana, if I found out Reggie had, this is after the death, if I found out Reggie had been sleeping with Jennifer, I could never forgive him for that. Warren denied saying that. He then wanted to call Dana, introduce extrinsic evidence for impeachment purposes. That's the only ground that was presented to the trial court. And the trial court said, well, that's a collateral matter. What he was attempting to show from that was an omission. The fact that Warren didn't say, well, I couldn't forgive Reggie if Reggie killed Jennifer, that means Warren knows that Reggie didn't kill Jennifer because Warren did really kill Jennifer. It was this whole speculative, asking the jury to jump over, huge gaps in proof. But basically, he just offered to the trial court, I want to call Dana just to impeach Warren that there was some jealousy.
Counsel,
but again,
did he ever articulate a third-party culpability theory, either before the trial started or during?
I'm sorry, Your Honor?
The defense lawyer ever articulate a third-party culpability theory before or during the trial?
In the beginning, before the trial actually started, the people brought up the issue, because we had made a motion in limine that if the defendant intended to cross-examine Warren on the life insurance policy, that we asked for an offer of proof, because we believe that was not enough under the case law, to go down into the path of third-party culpability. And then the defendant answered that and gave a proffer. And when the court said that's enough, that's not enough, and denied it, he then denied he was doing
that. Was the proffer I'm going to blame Warren, or was the proffer I'm just going to use it to negate the idea that someone else could have had no one else could have had a motive to do this? Did he articulate the theory, I am going to use this to blame Warren?
I don't believe he articulated it that way. He kind of articulated that I just want to point the finger away from myself, show other people could have done it. Countless other people could have done it. But he was making an argument that he was accusing Warren, and if he's not accusing Warren, all these questions that he was asking were largely irrelevant. Where Warren was at the time, whether he keeps gloves in his car, his lack of reaction to seeing her garbage cans left on the street, all that would be irrelevant if he wasn't accusing Warren.
Right. So that's my question. Was he accusing? Did he ever articulate a theory to the court that he was going to use this to accuse Warren?
He wouldn't admit that. He kept on saying, well, I'm just trying to – basically he was saying I want to throw everything out there and, you know, maybe I can confuse the jury. He would never admit that that's what he was doing. And he conceded that he did not have enough under Primo. And he was trying to get through the back door what he couldn't do through the front door. But I did want to just briefly state that the constitutionality of the Primo standard is not a question of law that this Court can decide. He cannot claim that he preserved that issue, whether third-party culpability standard under Primo is constitutional, when he was denying that his proffered evidence had anything to do with third-party culpability or Primo. He not only didn't do it, it would have been impossible to do, disavowing that defense, and yet preserving the issue for this Court's review.
Thank you, Ms. Wager. Mr. Gaetani?
Well, just with respect to that last point, it's actually preserved because the trial judge was deciding that, notwithstanding the right to present a defense and Chambers versus Mississippi, that under Primo, it was going to limit what the defendant can do. I just want to clear up something about the DNA. It's very clear from the trial record that the defendant's DNA profile was excluded from the red necktie, which is a substantial piece of evidence with respect to the homicide because it was used to bind the victim's hands. With respect to the left fingernail clipping, there was evidence there that showed the presence of more than one male. Could not be specific with respect to who either one was, but the presence of more than one male, and that's clear from the record.
And, counsel, could you point me to where in the record your client's, the defense lawyer specifically raises accusing the brother of committing this crime?
Your Honor, before this case went to before jury, I think it was during jury selection, the people made this motion for a prospective ruling. So at that point, it's very early on in the case. The judge says, well, I'll keep an open mind, but I'll tell you what, if you don't, he's not in the house, I'm not going to go for this. The defendant at that point, he's a trial attorney, he's playing it close to the vest. He's not going to tell what his defense is right from the get-go.
But at some point, when this is going through the trial and these facts line up to show access to the house, does he ever articulate the theory, I'm going to use this to point the finger at Warren?
He's already been shut down. The judge has already told him if he's not in the house, you're not going to bring in evidence of third-party culpability. Why does he just keep on butting his head against?
Was that on the response to the people's motion where you could have said, in response to that motion, because I want to use this to point the finger at Warren?
Judge, that was before the trial started.
I had the same question. I was wondering, is he just doesn't want to say something that's going to get Warren convicted in the next trial? I mean,
Judge,
it made no sense.
I think very on when this motion is made, before the selection of the jury is completed, He doesn't want to reveal what his defense is going to be,
so
and
what?
I don't think he's required to reveal
But
what
if
his
you're
defense is
going
going
to
to be.
bring in a motive, like $500,000 life insurance policy, aren't you kind of tipping your cards?
Right.
I mean, I would think he'd be jumping up and down saying it was my brother, it was my brother, it was my brother.
Well, Judge, they brought in the policy. They reveal the fact that that happened. And if I could just finish with one or two points.
Sure.
With respect to Dana, it wasn't collateral. The defendant said it wasn't collateral. And there's a case I cited in my brief, the Second Circuit case, and I'd ask the Court to take a look at that, Alvarez. And this Court's own decision in Carroll, when you're talking about extrinsic evidence to prove motive, it's a different story. But I don't know, I don't have any time now, but there's other compelling evidence here. And Judge Lippman used the term in Negron when he was talking about the fact that there wasn't anybody who put the witness in that case in the house. He talked.
I'm sorry. Did counsel concede that there wasn't enough evidence to proceed under Primo? That's what your adversary says. Is that true?
I think he said, Judge, you indicated there's not enough evidence. So he was.
Judge indicated that?
Yeah, he was parroting what the Court said, that there wasn't evidence. But I think there is enough evidence. There is, in addition to the motive, which, if it was proved, there's proximity, there's access, there's this evidence of, with the garbage cans and the phone call from the friend, and Warren doesn't go over, given the relationship they had. Evidence which.
Anything at all connecting him to the crime or the scene of the crime?
There's no witness that puts him in the house. But neither was there a witness in Negron. There was evidence which Judge Lippman characterized evincing a consciousness of guilt. And I think with respect to the garbage cans, this is somebody who would let themselves into the house during his route to get some drinks for himself and his friend. Passes by one day, doesn't see that the trash can's been removed, and this is a meticulous person. Comes back again, doesn't see the recycling is put out, doesn't do anything. The next night when the body's discovered, gets a call from her best friend. Hey, Warren, there's sirens. The police have a big presence at her house. He calls, but he doesn't go over to see what happened, given the fact that, well, maybe he connects it to the trash cans, because he knows the daughters are away. He knows she's home. So there was a lot of other compelling evidence in this case, the forensic evidence. It wasn't just the fact that there was a life insurance policy.
Thank you,
there was
Mr.
more.
Gaetano.
Thank you, Judge.